Welcome to the Special Education News Roundup. I'm your host, Jennifer Price, with a story that doesn't have a lot of meat on the bones, I'll tell you, because the judge made a ruling in the case early in its stages. However, I did want to bring this case to your attention for very other important reasons. So the child is named BD, and BD is an 18-year-old child with Down syndrome. He has been identified as intellectually disabled and received special education services at his school. Now, he had been receiving an IEP since he was in the second grade. And since the second grade, BD's parents had been working with the educators in the school to create IEPs with rigorous goals, with the ultimate goal that BD graduate with high school with a standard diploma as opposed to something like a GED. So in 2015, BD entered high school and an IEP was developed and agreed upon by everyone. But shortly after the IEP was put into effect, things began to go downhill. BD wasn't provided the services that were called for in the IEP. And some of the teachers and specialists didn't agree with the goals in the IEP. So therefore, they chose to work with BD towards other goals. Okay, are you ready for this? BD was allowed to avoid academic participation and instead watch YouTube videos. I'm not really sure what kind of education he was getting on YouTube that would be superior or even equivalent to what he would have received from the teachers and the specialist. Then of all things, the special education team began to suggest new IEPs that didn't require as much rigor. Well, BD's parents refused that adjustment, and shockingly, BD's grades dropped, and he even regressed in some of his classes. So the parents filed a complaint, and they claimed discrimination under Section 5 and the ADA. The school sought an early dismissal of the case, and thankfully the judge denied that ruling in those early stage proceedings. A reasonable person could find, the judge said, that the district acted in bad faith or used gross misjudgment. Okay, so here's the ruling. First, this case withstood a motion to dismiss. And without getting too legal and technical, this is a move most defense attorneys make at the earliest stage in the proceeding. So this case still has a lot of life left in it, and it could go to trial. But that said, this was a no-brainer that the court would not dismiss the case this early in the stage of the proceedings. So I'm talking about this case because it's important to note that you as parents are first and foremost the experts. And because you are experts and you know your child, don't allow schools to just provide some inferior education simply because he or she has a disability. I firmly believe a teacher would not be quite as comfortable to allow a student to receive his education from YouTube unless that teacher thought that she could get away with it. That said, I don't think a teacher would think that she could get away with it. And I think that especially on an able person versus a disabled child. Now, I could be wrong, but between allowing the child to watch YouTube videos and then seeking to change the IEP to make that IEP less rigorous really brings up the question of why this person is even in a teaching position. So when you see this happening, teachers who don't want to teach, say something, do something. Your child deserves a quality education just as much as any other able child, and with or without an intellectual disability. And that disability should never be a barrier to that. This mom refused to give in, and it just may pay off in the end. Again, this case is early in the stages of the life of it, but at this point, we're talking about it because I did want to remind you to never settle for a less rigorous IEP or any other kind of inferior education, especially when the reason is because the teachers simply apparently don't want to teach. It's their job to teach your child. That is what your tax-paying dollars are going towards. That is a part of the definition of a free, appropriate public education. Until next time, folks.